When a director is responsible for company debts, directors can face personal exposure when companies fail. Limited liability should afford directors protection as and when companies fail, for instance, going into liquidation. There are, however, instances when this protection is removed, and we're going to detail some of these here. The main three we encounter are 1. Personal guarantees, 2. Overdrawn directors' loan accounts, and 3. Misconduct or wrongdoing in the view of the liquidator. Very often directors are required to sign a personal guarantee where they receive any line of credit. The easy bit is signing and committing to a personal guarantee based on your assets. The difficult part is when a business fails and a claim is made on this PG. These have to be resolved, and very often they involve litigation. These cases can be extremely complex and only ever resolved by experts. When a PG is called upon, or triggered as we call it, very often legal proceedings commence straight away. And the options open to any creditor and or their solicitors are many, including statutory demands, bankruptcy, county court judgments, and orders charging land. If not dealt with correctly, costs can very quickly accumulate and be added to the PG claim. The next area of personal exposure, potentially for directors, is that of overdrawn directors' loan accounts. A liquidator, when appointed, will assess the accounting records and determine whether you as a director actually owe money to the business. This can take the form of cash withdrawals and or what are deemed to be illegal dividends. This will ultimately culminate in a claim. Liquidators are quite aggressive in these matters, in that you are indebted to the company and they are required to recover it for the benefit of the creditors and or their fees. A claim by a liquidator on an overdrawn director's loan account is obviously against you personally, and merely saying that it's the accountant's fault does not resolve the issue. Very often the amounts are disputed, but that is where we come in because we specialise in this niche. Another area of a liquidator's work is when they have to review your conduct as a director. Essentially, they need to establish whether there was any wrongdoing or misconduct on your part, and this can take many different forms. In severe cases, this can be a criminal action, but in the main, they're looking for some sort of civil remedy. The main concept that the liquidator works on is to ensure that you have conducted your fiduciary duties as a director. If a liquidator deems that a director has failed in their fiduciary duties, they can take one of two courses of action. 1. Director's disqualification, or 2. Some form of civil proceedings. A few examples of misconduct or failure in their fiduciary duties are 1. Misappropriation of company funds, 2. Trading insolvently, 3. Abuse of COVID financial support, 4. Preferring creditors. There are others, but hopefully this gives you a flavour of what the liquidator is looking at. Regardless of your situation, in liquidation, if personal exposure is proven, your assets are at risk. As a director, it's never too late to find out your options, so merely contact us here at Bell & Company today.